Before I even knew I had a daughter, my ex had already rewritten my life, used my frozen DNA without consent, told the court I was unstable, and built a legal narrative where I was the woman who abandoned her own child. He did not just lie about me. He constructed a version of reality where I questioned my own memory, my own sanity, my own worth as a mother. He opened accounts in my name, prepared custody filings years in advance, and waited for the perfect moment to accuse me of being unfit. He thought if he controlled the story, he controlled me. He was wrong. My name is Adeline Mercer, and this is how I dismantled the lie he tried to turn into my identity. Chapter 1. The Call That Shouldn't Exist. My name is Claire Donovan. I am 43 years old, and until last Thursday evening, I believed my life was documented, structured, and entirely under my control. I am a senior architect at Harbor Line Environmental Design in Portland, Oregon. I design public schools and municipal buildings, places meant to be safe and permanent. I live alone in a brick townhouse in Selwood. I have never been married. I have never had a child. At least that was true at 6:42 in the evening on June 12, 2025. I was still at my desk, reviewing revisions for a library renovation, when the main office line rang. Most of the staff had gone home. I almost let it go to voicemail. "This is Claire Donovan." The woman on the other end introduced herself as Principal Ellen Murray from Oak Ridge Elementary in Lake Oswego. Her tone was controlled, but strained. "Ms. Donovan, your daughter is still here waiting to be picked up." "There must be a mistake," I said. "I do not have a daughter." She paused. "Our records list you as the legal guardian of Lily Donovan. She has been waiting nearly 3 hours. She says her mother is coming." Legal guardian. I felt my mind shift from confusion to calculation. I asked her to read back the information on file. She gave my full name, my current address, and the last 4 digits of my social security number. She said they had a copy of my Oregon driver license and my signature on the enrollment paperwork. If this was an error, it was detailed. If it was intentional, it was dangerous. "If you are unable to pick her up," she added carefully, "we are required to escalate to the district. In some cases, Child Protective Services becomes involved when a guardian cannot be reached." CPS. I told her I would be there in 30 minutes. The drive to Lake Oswego felt unreal. The sky was flat and gray. My thoughts moved quickly now. If my name was legally tied to a minor child, someone could claim financial responsibility, someone could file for custody, someone could demand years of back child support. This was not just emotional confusion, this was exposure. Oak Ridge Elementary was almost empty when I arrived. The front doors were locked. Principal Murray buzzed me in. The hallway lights were dimmed. The building felt hollow. She led me into the office, and that was when I saw her. She was sitting alone on a molded plastic chair, a small backpack clutched in her hands. Brown hair pulled into a ponytail, blue-gray eyes that lifted the second I stepped inside. She stood. "Mom." She did not hesitate. She did not question. I felt something inside my chest tighten and go still at the same time. I looked at her face carefully, clinically. There was a thin, pale scar on the left side of her upper lip. I have the same scar from a bicycle accident when I was 6. Children do not replicate their parents exactly, but certain details echo. The line of her jaw, the crease between her brows when she concentrated, the way she held her shoulders slightly forward. Principal Murray handed me a folder. Kindergarten enrollment from August 2024, parent name Claire Elizabeth Donovan, address matching mine, no secondary guardian, father listed as Ethan Cole. Ethan. We were engaged from 2018 until October 2020. I ended it after discovering he had been logging into my email and transferring money from our joint savings without telling me. I cut him out of my life completely. The birth date on the form read March 12, 2020. In March 2020, I was living in Denver for a 7-month project. I had lease records, corporate expense reports, timesheets. Principal Murray compared my driver license to the copy in the file. The signatures matched perfectly. "We have to document everything carefully," she said. if you are not her legal guardian, we need to clarify that immediately." The girl looked up at me. "Dad said you were busy, but you would come." Dad said. I asked her name. Lily Rose Donovan. The last name landed harder than the word mom. District policy required a booster seat for children under 8. The school nurse installed one in my back seat while I stood in the parking lot trying to keep my breathing steady. Everything felt procedural, as if the system had already decided I belonged to this child. On the drive back to Portland, Lily sat quietly. After a few minutes, she said she knew I worked a lot, but she did not mind waiting. She asked if we were going home. Home. When we reached my townhouse, she stepped inside without hesitation, looking around as if confirming something familiar. I showed her the guest room. She asked if her old stuffed rabbit was still here. Old. I made pasta because it required no thought. She ate neatly, telling me about her teacher, about a science project about a birthday cake I apparently bought last year. After she went to bed, I sat alone at the kitchen table with my laptop and the documents Principal Murray emailed me. There was a scanned birth certificate issued in Multnomah County. Mother, Claire Elizabeth Donovan. Father, Ethan Michael Cole. Child, Lily Rose Donovan. Date of birth, March 12, 2020. The seal looked legitimate. The formatting matched official records. I opened my archived calendar from that year. March 2020 was full of Denver site inspections and contractor meetings. There was no gap large enough to hide a pregnancy and a hospital stay. At 10:43 that night, another email arrived from the district with the original registration packet. At the bottom of the final page, beneath a paragraph about medical consent and financial responsibility, was my signature. Not similar, not close, exact. Medical consent, financial responsibility. If this stood in court records, someone could use it to demand custody. Someone could claim I had abandoned my own child. Someone could come after my income. I leaned back in my chair and stared at the ceiling. I have built structures my entire life. I know how to read stress lines. I know how to find load-bearing beams. This was not a clerical mistake. It was engineered. And Ethan Cole did not make accidents. He made plans. If he built this, I was going to take it apart piece by piece. Chapter 2. The consent I never gave. The next morning, I began with the only place that could tell me whether my past had been altered without my knowledge. In 2016, when I was 34, I froze my eggs at Pacific Crest Fertility Institute in Portland. I was not ready to become a mother, but I wanted the option. Ethan had sat beside me in the consultation room, holding my hand, telling the doctor we were planning responsibly. At 8:10 that morning, I called the clinic and asked to speak with the medical director. "This is Claire Donovan. I need to review my reproductive records from 2019. I was transferred to Dr. Laura Bennett. Her voice was calm, almost warm. "Claire, it has been some time. What can I help you with?" "I need to know whether any of my stored eggs were released or used." There was a pause, then the sound of typing. "According to our records, in June 2019, your eggs were thawed and a transfer was performed." The room seemed to tilt. "That is not possible." "We have a consent form on file," she said carefully, "signed and notarized." I drove to the clinic immediately. The waiting room was full of couples whispering, clutching folders. I felt detached from them, as if I were walking into a courtroom instead of a fertility center. Dr. Bennett met me in a consultation room and placed a file on the table. "The consent is dated June 3, 2019. Identification was verified at the time." I opened the form. There was my name, Claire Elizabeth Donovan. There was my signature, the curve of the C, the tight angle of the D. "I never signed this," I said. She studied me closely. "The notarization includes a state seal and ID confirmation. If this was unauthorized, it would constitute serious civil liability." Civil liability. Those words settled heavily. I took digital copies of everything, including the notary information, and left. By noon, I was sitting across from a reproductive law attorney named Marcus Hale in downtown Portland. He listened without interrupting as I laid out the timeline. You froze eggs in 2016, he summarized. In 2019, there is a signed authorization. In 2020, a child was born listing you as the mother, and now the child appears with enrollment documents naming you legal guardian. Yes. Did your former fiancé ever have access to your medical portals? He knew my passwords at one point. Marcus folded his hands. If this consent was forged, we are dealing with reproductive fraud and identity theft. If it was manipulated under false pretenses, it may also impact parental rights and custody claims. He contacted a licensed notary verification service. Within hours, we learned that the notary listed on my form had been formally disciplined in 2023 for improper identification procedures. That weakens their credibility, Marcus said. It does not prove fraud, but it creates doubt. He recommended immediate DNA testing through a certified laboratory with documented chain of custody. He also suggested hiring a private investigator. People do not engineer something like this without a financial motive, he said. That afternoon, I provided a cheek swab at an accredited lab while Lily sat beside me, swinging her legs. Are we doing science? She asked. Yes, I said softly. We are confirming something important. When we left, she slipped her hand into mine. I felt the weight of it. That evening, Marcus called. Our investigator has preliminary findings. The investigator, a former detective named Aaron Delgado, had reviewed Ethan's financial records. In 2023, he lost nearly $200,000 in speculative real estate ventures in Nevada. Outstanding debt remained. There is more, Marcus continued. In 2021, a secondary credit card was opened in your name using a previous address tied to you. Over the last 3 years, it has been used to pay several family law attorneys. My pulse slowed instead of racing. He was preparing. If he established you as the biological mother, he could pursue financial obligation through child support. Given your salary at Harborline Environmental Design, that amount would not be insignificant. My income was public through municipal contracts. Ethan knew exactly what I earned. Later that night, my phone rang from a number I did not recognize. Claire. I had not heard his voice in 5 years, but I recognized the tone immediately. Calm, controlled. You forged medical consent, I said. I did not forge anything. You signed it. I was not even in the state. You travel constantly, he replied. It's hard to remember where you were. You are positioning me for financial liability? He laughed softly. You always wanted a family. I made it happen. How much are you planning to ask for? He hesitated briefly. You make more than I do. That is simply math. It was not about a child. It was about leverage. 2 days later, Marcus called me into his office again. He slid a document across the desk. Petition for primary custody filed in Multnomah County Family Court. Petitioner, Ethan Michael Cole. Respondent, Claire Elizabeth Donovan. He is requesting primary physical custody of Lily and seeking child support based on your income. He alleges abandonment shortly after birth and claims you refused to participate in the child's upbringing. I read the affidavit slowly. It described me as emotionally unstable during pregnancy and unwilling to bond. He rewrote my character to support his strategy. There's a hearing scheduled in 14 days, Marcus said. He is also requesting temporary custody orders pending final review. Temporary custody. If granted, Lily could legally be placed with him while the case proceeds. If you fail to respond promptly, the court can issue orders by default, Marcus added. We cannot miss a deadline. That night, Lily sat across from me at the kitchen table, drawing a picture of a house. She looked up. Dad said sometimes grown-ups have to go to court. Are we going to court? Yes, I said carefully. Did I do something wrong? No. I felt something shift inside me. The legal filings were no longer abstract documents. They were pathways that could remove her from my home. Marcus called again the next morning. The lab expedited your DNA results. We should have confirmation within 72 hours. If she is biologically yours, your parental rights strengthen significantly. If not, this becomes a different legal battle entirely. Everything hinged on that result. I stood in my kitchen staring at the petition again. This was not a misunderstanding. It was a long game built on forged consent, financial pressure, and calculated timing. And now the court system was part of it. Chapter 3. The DNA I couldn't ignore. The 72-hour wait did not feel like time passing. It felt like standing in the center of a custody battle before the first ruling had even been made. Marcus scheduled the DNA test through a certified laboratory in Portland with full chain of custody documentation. Every step was logged, every sample sealed. If this case reached family court, the results needed to withstand scrutiny. Lily sat beside me in the waiting room, swinging her legs against a chair. "Are we in trouble?" she asked quietly. "No," I said. "We are making sure the truth is clear." "Are you my real mom?" The question hit harder than any legal document. "I am going to find out," I said gently. The technician swabbed the inside of my cheek, then Lily's. The samples were placed into tamper-proof envelopes, barcoded, photographed, logged into a digital system. Evidence, not emotion. As we left, Lily slipped her hand into mine. "Dad said you didn't want me," she said without looking up. My chest tightened. That is not true. That night, I barely slept. Every scenario ran through my head. If the tests came back negative, I would fight to remove my name from every record and challenge the fraudulent consent. If it came back positive, this would become a parental rights case in a full custody battle. The next morning, Marcus called. CPS has opened an assessment because of the abandonment allegation. A caseworker will conduct a home visit. By mid-afternoon, Rebecca Larson from Multnomah County Child Protective Services stood in my living room with a clipboard. "I understand this is part of an ongoing family court dispute," she said. "It is." She walked through the townhouse methodically. She checked smoke alarms, medication storage, food in the refrigerator. She examines Lily's temporary bedroom. "How long has she been here?" Rebecca asked. 4 days. "Did you know about her before that?" "No." Rebecca's expression did not change, but she wrote something down. She knelt in front of Lily. "Do you feel safe here?" Lily nodded. "Does Claire take care of you?" "She makes pasta," she repeated as if that was the ultimate proof. Rebecca stood again and lowered her voice. "I understand is now being shotgunned through the system, which means every caseworker in Multnomah County can now see it," she said. "If the court believes abandonment occurred, that can significantly affect custody determinations. Temporary custody orders can be issued quickly in these cases." "I did not abandon her," I said evenly. "I did not know she existed." "I will include that in my report." The door closed behind her and the house felt fragile for a moment. At Harbor Line Environmental Design, the pressure followed me. I was called into a meeting with Human Resources and one of the partners. "We received an anonymous email referencing a custody dispute and allegations of abandonment," the partner said. "There is a pending legal matter. There has been no court order against me. Will this affect your ability to maintain current municipal contracts?" "No." The words felt like placing steel beams into position. I needed my career intact. Ethan understood that. That night, Lily crawled into my room again. "Are you going to court because of me?" she asked. "I am going to court to protect you," I said. She studied my face. "Are you really my mom?" The question lingered in the air between us. "I am going to find out tomorrow," I told her. The third day arrived with unbearable clarity. Marcus asked me to come into his office in person for the DNA results. He had the lab report open on his desk when I arrived. "This is certified and admissible in family court," he said quietly. I sat down. He turned the page toward me. "Probability of maternity, 99.98%. For a moment, everything went silent. "So there's no doubt," I said. "No legal doubt," he replied. "You are her biological mother. That strengthens your parental rights significantly in this custody battle." The words shifted something fundamental inside me. Lily was not just a legal risk, she was mine. Anger arose, sharp and focused. He used my genetic material without consent, which supports a claim of reproductive fraud. Combined with identity misuse, this becomes serious. The court will not ignore that. My phone vibrated before I could respond. A notification from the Multnomah County Family Court portal. Ethan had filed an amended affidavit. Marcus opened it quickly. He's escalating. The document described me as emotionally unstable during pregnancy. It claimed I asked him to handle medical arrangements privately because I feared career damage. It alleged I refused contact after birth and showed no interest in the child. He's framing this as a parental rights case where he has been the sole caregiver, Marcus said. He's requesting expedited temporary custody. How soon? There's a preliminary hearing scheduled in 12 days. 12 days. If a judge granted temporary custody at that hearing, Lily could legally be placed with him while the case continued. That was how family court operated, fast interim orders based on limited information. "He thinks DNA traps me," I said slowly. Marcus met my eyes. "It does the opposite. It gives you standing." I left his office with a copy of the certified results in my bag. The weight of the paper felt heavier than it should. When I walked into the house, Lily was at the kitchen table coloring. "Did the doctor tell you something?" she asked. "Yes." She waited. "It means I am your mother." She smiled slightly as if this confirmed something she had always known. "I told Dad that," she said. Her certainty settled over me in a way no lab report could. Later that evening, Marcus called again. "We are filing a counter petition," he said. "We will assert your parental rights, challenge the fraudulent consent, and oppose any temporary custody order. We will also request the court review potential financial manipulation." This was no longer defensive. This was strategic. Ethan had tried to turn biology into leverage and the court into a weapon. But the DNA had changed the equation. It did not trap me. It armed me. Chapter 4. The Courtroom Record. The morning of the hearing felt less like anxiety and more like alignment. Everything that had been hidden was about to enter a public court record. Marcus arrived early with 2 binders and a calm expression that I had come to rely on. "This is a temporary custody hearing in family court," he said quietly. "But the judge will remember what gets entered into record today." Ethan stood across the hallway with his attorney. He looked composed, almost patient, as if he believed this was still a negotiation he could manage. Inside courtroom 4B, Judge Harold Benton took his seat and reviewed the docket. "This matter concerns a petition for primary custody and temporary custody pending further proceedings," he began. "Allegations of abandonment have been raised." Ethan's attorney spoke first. "My client has been the sole caregiver since birth. Ms. Donovan chose professional ambition over parental responsibility." Ethan took the stand. "I did everything I could to include her," he said. "She said she was not ready to be a mother. She asked me to handle it." His voice was steady, practiced. Marcus rose slowly. "Your Honor, this is not merely a custody dispute. This is a parental rights case involving potential reproductive fraud." The room shifted. He approached the bench. "We submit into record certified DNA results confirming Ms. Donovan as the biological mother. We also submit travel and employment documentation establishing her physical presence in another state at the time of the alleged consent. Additionally, we submit notarization records showing disciplinary action against the notary involved." Judge Benton examined the documents carefully. Marcus continued. We further submit financial records demonstrating a credit account opened under Ms. Donovan's name without authorization, and evidence of multiple family law consultations years before Ms. Donovan was notified of the child's existence. He signaled to the clerk. Exhibit E, electronic correspondence dated June 2019. The screen displayed the email. She does not need to know yet. Marcus turned toward Ethan. Mr. Cole, did you send this message? Ethan shifted. I do not recall the context. The context, Marcus said evenly, is the activation of Ms. Donovan's stored genetic material without informed consent. Ethan's attorney objected. The judge overruled. Judge Benton leaned forward. Mr. Cole, did Ms. Donovan personally sign the consent form in your presence? Yes, Ethan replied quickly. Marcus placed another document before the judge. Metadata analysis indicates the signature was digitally reproduced. Furthermore, Ms. Donovan's verified employment records place her in Colorado at the time of the alleged signing. Silence settled over the courtroom. Judge Benton spoke slowly. This court is tasked with determining the best interest of the child. However, the evidence presented raises serious questions regarding the circumstances under which this child was conceived and documented. He looked directly at Ethan. Family court does not operate on deception. I felt my shoulders relax slightly for the first time. Judge Benton continued. The certified DNA establishes Ms. Donovan's biological parental rights. Based on the evidence submitted, the motion for temporary custody is denied. Temporary custody will remain with Ms. Donovan pending further review. A clear ruling. Entered into record. Ethan's expression tightened. Judge Benton was not finished. The exhibits also suggest potential criminal conduct, including reproductive fraud and identity misuse. The clerk is directed to forward relevant documentation to the district attorney for evaluation. The words criminal conduct hung in the air. Behind Ethan, his mother Diane lowered her gaze. When the email was displayed again, she did not look at him. Marcus leaned close to me. This family court ruling establishes your standing, he whispered. It is significant. The gavel struck once. Outside the courtroom, Ethan approached me, his composure cracking at the edges. You are making this worse than it needs to be, he said. I did not make this, I replied. You could have handled this privately. You decided I did not need to know, I said evenly. That decision is now part of the court record. He exhaled sharply. You are trying to destroy me. I am correcting the record. He stepped closer. You think a ruling today ends this? No, I replied. It begins accountability. He walked away without another word. Marcus and I exited the building into the afternoon light. This was only a temporary custody hearing, he reminded me. There will be additional proceedings, but today the court recognized your parental rights and denied his motion. That matters. It's on record now, I said. Yes, and once entered, it cannot simply disappear. I stood on the courthouse steps and allowed myself one steady breath. For weeks, I had felt like I was chasing a lie. Now the truth had been documented. That evening, when I returned home, Lily was at the kitchen table coloring. Did the judge say something? I asked. Yes, I said. Was it good? It means you are staying here. She nodded as if she had expected nothing else. Later that night, I logged into the court portal and saw the ruling uploaded. The denial of temporary custody, the acknowledgement of biological parental rights, the referral to the district attorney. Public record. Ethan had tried to construct a narrative in private. He had believed that paperwork forged in quiet rooms would hold more weight than truth. Instead, the truth was now stamped, filed, and preserved. He built a story on deception. I entered the evidence into record. And once something is written into a courtroom transcript, it doesn't fade. Chapter 5. The Name She Kept. The final custody hearing was set for October, nearly 4 months after the afternoon that began with the school phone call and ended with my entire past unraveling. By then, this was no longer just a dispute. It was a documented parental rights case with a certified record. Marcus walked into the courtroom carrying a binder thick with certified DNA results, the CPS closure report, employment verification from Harborline Environmental Design, notarization disciplinary records, and the transcript from the prior family court ruling. Ethan sat at the opposite table. He looked smaller than I remembered, not physically, structurally, like something inside him had shifted from confidence to calculation. Judge Harold Benton entered and called the matter to order. This court has reviewed the evidence previously entered into record. Today we addressed final custody determination. Ethan's attorney made one last attempt. My client requests shared custody. He acknowledges mistakes but maintains he acted in what he believed to be the child's best interest. The phrase best interest no longer carried weight. Marcus stood. Your Honor, the record reflects unauthorized use of stored genetic material, falsified consent documentation, identity misuse, and financial manipulation. The court previously denied temporary custody. Today we request full legal and physical custody based on established parental rights and documented misconduct. Judge Benton turned to me. Ms. Donovan, do you wish to make a statement? I stood. I did not abandon my child. I was denied knowledge of her existence. When I became aware, I acted immediately to protect her and to correct the record. The courtroom was silent. After a brief recess, the judge returned with his decision. This family court ruling grants full legal and physical custody to Miss Donovan. The words landed with precision. The petitioner's parental rights are terminated pursuant to findings of deception, misrepresentation, and conduct inconsistent with the integrity of the custodial process. Terminated, not suspended, not shared. This order shall be entered into permanent record effective immediately. It was done. Outside the courtroom, Ethan did not approach me. His attorney spoke quietly to him. His mother stood beside him with her hands clasped tightly. She stepped toward me once he had moved away. I did not know, she said softly. I believe you, I replied. There was nothing else to say. 2 weeks later, the certified custody order appeared in the online portal. Full custody granted, parental rights terminated, final judgment entered. At the same time, the district attorney's office confirmed that the criminal investigation into identity misuse and reproductive consent violations remained under review. His name was attached to that review. Ethan's brokerage firm terminated his contract after learning of the court findings. Accountability did not require applause. The name change petition was approved shortly after the final ruling. I sat at the kitchen table with Lily and placed the form in front of her. You get to decide. You can keep your last name or you can take mine. She studied the papers seriously. What is yours again? Donovan. She picked up a blue pencil and slowly wrote it across the page. Lily Donovan. She looked up at me. I want the same one. The amended birth certificate arrived in a thick envelope 3 weeks later. I opened it standing at the counter. Mother listed as Claire Elizabeth Donovan. Father line amended per court order. Full custody granted to mother. It was not about erasing the past. It was about restoring what had been taken. Child Protective Services officially closed their file with no findings and a notation of stable environment and appropriate parental bonding. Harborline's partners never mentioned the matter again. My professional reputation remained intact. One afternoon, a message came through a new number. Can I see her one more time? I did not respond. I forwarded it to Marcus. You are under no obligation. All communication must proceed through counsel. I deleted the message. On a quiet Saturday morning in November, Lily sat at the kitchen table drawing another house. She pressed hard with the blue pencil when she wrote our name across the roof. Donovan. Mom, you are not leaving, right? I knelt beside her. I am not leaving. She nodded and returned to shading the windows. There was no spectacle, just light through the kitchen window and a child who no longer woke up afraid of being left behind. I did not just win a custody case, I reclaimed my name, my consent, and my place in my own story. This was not revenge, this was restoration. Ethan built a plan that depended on secrecy, forged signatures, and financial leverage. He believed silence would protect him and confusion would protect his narrative. Instead, the truth was certified, filed, and preserved in a courtroom transcript. Full custody granted, parental rights terminated, identity restored. If someone has ever tried to rewrite your story, manipulate your consent, or use the system against you, what would you have done in my place? Share your thoughts below. Tell me if you have faced something similar, and if you believe documentation, truth, and accountability still matter, stay with this channel. There are more records that deserve to be set straight. If you value stories where strength is quiet but unshakable, subscribe.